Hi friends, this is Adv.Rahul Mhaskar and founder of Hammurabi Tablet, a forum formed for the purpose of quenching the thirst of legal knowledge. In the present case, the Hammurabi Tablet is going to overview the new act which has come in Maharashtra, that is the Real Estate Regulation and Development Act 2016. On 1st of May 2017, this act has come in operation in Maharashtra. The rules regarding the same were notified on 20th of April 2017. So let's begin our journey and try to understand what this new act has to do. At first, we will see what are the basic new changes which have come into this particular act. This new act has done several changes, and those changes can be reflected when you see particular sections. For example, there is a section 3, registration of real estate project. Then there is a 70-30 concept which has been introduced in the particular act, wherein a separate account has to be operated by a promoter, wherein he has to deposit 70% of the amount which he receives from allotee. Now this is something a really new thing, and we will deal with this detail as we go ahead in this discussion. Then for the first time, the real estate agents have been made to be compulsory registered under section 9, and that is one of the really new concept and a beneficial thing which would happen. Formation of regulatory authority, formation of real estate appellate tribunal, civil courts would be barred from entertaining any disputes which would occur from this particular act. Now this is based on the concept of, as there is an authority, subsequent to authority there is an appellate tribunal. So this particular thing has changed. Now when we travel further, there is one thing which we need to understand, and that is which are the statutes which are being repealed. Now there is only one particular statute which was there in Maharashtra, and that has been repealed, and that is Maharashtra Housing Regulation and Development Act 2012. This is the only statute which was prevailing in Maharashtra prior to the Rera has been now repealed. Then we will see which are the statutes which are still in force when the Rera is going to function. Number 1, MOFA. MOFA will still stay. MOFA will have its effect in Maharashtra in spite of there being a Rera. Consumer Protection Act, again it will stay in spite of having some mechanism for resolution of disputes in Rera. Now an important thing which particularly needs to be understood is that when there is an inconsistency between two laws, say there is inconsistency between MOFA and at the same time the Rera speaks something else, it has been made very clear as per section 89 of Rera that in such cases Rera will prevail upon them. Now let's try to see what are the chapters in Rera. The chapter 1 is preliminary, that's normal, a short title. Then chapter 2 has registration of real estate project and registration of estate agents. Chapter 3 is functions and duties of promoter. Chapter 4 is right and duties of the allottees. Chapter 5, the real estate regulatory authority. Chapter 6, there will be a central advisory council. Chapter 7, the real estate appellate tribunal. Chapter 8 defines offences, penalties and adjudications. Chapter 9, finance, accounts, audits and reports. And finally, it is a chapter 10 which has miscellaneous, which speaks about various other things. So we have started with this discussion as to how has Rera come, when the Rera is applicable. Now as we go ahead, we will start going slowly and gradually, picking up certain important and necessary definitions which we feel should be known to everybody. As we have seen the various chapters in the Rera, now we will travel to the various important and necessary definitions which we feel everybody should know, as they will really affect the manner and functioning of the Rera. The first is 2B. Rera defines what is an advertisement. Now this is one important aspect which every promoter has to keep in his mind, because any kind of a wrong advertisement, non-compliance of our advertisement is going to offer a penalty which is huge. Section 2D is regarding allotee. Now this is a term in which probably any person or every person, whoever buys any kind of an unit, a flat, a garage, anything is being included in this definition of 2D of allotee. Then 2J is building. What is building? It has been defined. Section 2K, carpet area, defines what is a net usable floor area of an apartment. It also covers internal partition walls of an apartment. Now this is something we really need to understand properly. Then 2N. 2N defines what are the common areas. Now it is very clear in Rera that whenever there is a layout project, all an entire common area will go to the apex or a federal body which would be formed. Then we have 2O, that is company. Now one thing which is more important in 2O is a development authority or any public authority established by the government in this behalf under any law for the time being in force. Now this is a new addition which has come. If you look MOFA always exempted the government bodies, and MOFA was not applicable to government bodies. This has drastically changed, and in Rera, even a government authority who is considered as a promoter will be equally liable for all the compliances of Rera along with the offences and penalties therein. 2V, estimated cost of real estate project. Now in this Rera, it is required that when a registration is done on the web page which is created of a promoter, an estimated cost of real estate project has to be mentioned. Now this may have counter effects, but this is law, so we have to go with this, because it is not possible or it is not advisable that the entire construction cost is displayed on a website. It may lead to certain wrong signals from wrong corners of society. 2Y is garage. What do you mean by garage? The entire definition is given over here. Then 2ZG, that is persons. Now here also in persons the last is any such other entity as the appropriate government may by notification specify in this behalf. So we have seen in company the government has been taken, in definition of person again the government has been taken. Then we have 2K. The basic definition is regards who is the promoter, who will be considered as a promoter. Now the manner in which, the depth in which the definition is mentioned here, it clearly shows that any person who contemplates to do a particular construction work either as a promoter, in a JV or in any form. So it's a very exhaustive definition of a promoter which has been mentioned in Rera. Here apex bodies, state bodies, all those minute activities which are there, which should be considered as a promoter, are mentioned. Then we have 2ZM. Now this is the definition of real estate agent. Now again if you see, the entire definition is very exhaustive. It contains not only the proper real estate agents, but it also contains property dealers, middlemen, referrals, because people thought that I will just refer this thing to builder and based on that I will be getting commission, and hence since I am only a referral I will not be considered as a real estate agent. Now which is not the case as per this particular definition. 2ZN defines real estate project. As to what is a real estate project has been defined exhaustively in this particular definition. Then we have 2ZQ, that is sanction plan. What is a sanction plan? How many plans to be sanctioned? One aspect which is needed to be understood as far as Rera is concerned, the manner in which the details are being sought on site. It contains from the beginning the plans which a promoter will sanction, a plan which promoter intends to sanction. Now these are some of the basic definitions which are important, so that any promoter has to keep them in mind, because any promoter, if flouts or creates any problem with these particular definitions, will obviously lead to a contravention leading to an offense in that. Now once we have seen the definitions, we will now first further travel to the significant features of Rera. We have seen various definitions which are there in Rera. Now we will see certain significant features of Rera. First is registration of a real estate project with Rera authority. Now this is something which is there because Maharashtra has formed this authority and they call it Rera authority. The registration with Rera authority is mandatory under section 3 subsection 1 of Rera. Now which are the real estate projects which would be covered under Rera and in which there is a necessity of having a registration under Rera? First, old projects where there is no occupation certificate, ongoing projects and new projects. So when we see this particular aspect, that even the old projects where the occupation certificate is not being obtained would come under the purview of Rera. Now as far as ongoing projects are concerned, the government has provided a 3-month window, so that if the act has come into effect on 1st of May 2017, the government has given a 3-month leverage, so that up to 31st of July 2017, the promoters can register their particular projects. Till that time, there is no offense, there is no penalty being given. Then we have certain projects which are exempted from Rera. First, where the area of land proposed to be developed does not exceed 500 square meters, or number of apartments proposed to be developed does not exceed 8, inclusive of all phases. So if the project is less than 500 square meters, or if the project is less than 8 apartments, in that case Rera will not apply. But the other part, and there is one more exemption given, is where the promoter has received completion certificate for a real estate project prior to the commencement of this act. In such cases, the registration under Rera is exempted. There is a third category for the purpose of renovation or repair or redevelopment, which does not involve number 1 marketing, number 2 advertising, number 3 selling or new allotment of any apartment, plot or building, as the case may be, under the real estate project. Now, there are certain rules which are being prescribed in the form. Here we see application for registration has to be made under section 4, and it has to be made as per the form A which has been prescribed under Rule 3, Sub Rule 3, along with a declaration to be filed in Form B as prescribed under Rule 3, Sub Rule 6. The concept of 70-30 is mentioned in Section 4. Registration is granted under Section 5. Extension of the registration is under Section 6. Registration can be revoked under Section 7. Now, after knowing this, we will try to see what are the obligations which are casted upon the real estate agents also. Now we will proceed to see the registrations and obligations of real estate agents. As per Rera, under Section 9, the real estate agent has to register. Now he has to comply as per Form G, which is prescribed in Rule 11.2. As per Rule 12.4, the registration of the real estate agent would be valid only for 5 years. There is a provision in Rule 13 for the renewal of the license of real estate agents. There are various obligations casted on real estate agent under Rule 14. Revocation of registration on breach of provisions mentioned in Rule 15. Rule 15 mentions certain breaches. If those breaches are being done by a real estate agent, his license and his registration would be cancelled. As per Rule 16, real estate agent has to maintain and preserve separate books of accounts, records and documents. Now this is an important obligation which has been casted on real estate agents, that they have to compulsorily mention separate kind of books which are totally different from their basic books of accounts. Now we will see duties of promoter under Section 11. The entire act itself is a duties of promoter, but there are certain more duties which are being given on the promoter. Upon receiving his login ID and password, promoter has to create his web page on the website of authority. Important thing is, advertising material should reflect the registration details of the promoter. Promoter is solely liable for the veracity of the advertisement or prospectus. One change which Rera has come is this: as per Section 13, promoter cannot accept more than 10% of the cost of apartment without executing an agreement. Now this is fundamentally 10% reduction as to what was available in MOFA. In MOFA, this same figure of 10% was of 20%. Now that has been reduced down to 10%. As per Section 14.2, alterations and additions which are to be done in the plans have been made very strict. Promoter has to obtain permission of 2/3 of the allottees. He has to obtain permission of 2/3 of the allottees to change any plans, any layouts. Promoter, if he wants to assign his project to another promoter, in that case also, as per Section 15, the promoter has to obtain 2/3 consent of the allottees, then only it will get transferred. And further, there has to be a written approval of the authority. Under Section 16, promoter has to ensure real estate project in respect of Now there are two things which are fundamentally mentioned here. One is title of a land and another is building and construction work. As far as title of a land is concerned, as on today, there is no specific insurance company who does that. But this may have a relation to one particular funda which was introduced, not introduced in Lok Sabha, but which was there in a form of a bill called Land Titling Bill 2010. This particular Land Titling Bill 2010 had created the entire mechanism for the purpose as to how a title of a land has to be registered. There would be a registrar of titles. So probably we think that this is the seed which will be helping to get once again introduced that land titling bill which was there in 2010. Then rights of allottees, duties of allottees. I think we need not speak anything more on this basically aspect, because the entire act is nothing but the right of the allottees, and the duties so called which are casted upon an allottee are very basic duties like making the payment on time, cooperating for the purpose of society. So we need not see that more because whole act is for them. Now let us see the various authorities which would be formed in Rera. We will now see the Real Estate Regulatory Authority. Now at the first, the authority is established and incorporated under section 20 of the Act. Authority has power to take suo motu complaint and call for information and conduct investigation. Now this one thing needs to be careful, that it is not that only on a complaint the authority can take the cognizance. If the authority suo motu takes a particular cause and feels that there is a necessity of an investigation, the same can be done by the authority. Interim orders can be passed by authority under section 36. Authority can issue directions under section 37. Authority has power to impose penalty or interest under section 38. Authority has power to rectify its order any time within a period of 2 years from the date of order made under 39. Now when we see all these powers of authority, it is very crystal clear that the authority has been given huge powers. They have power to take suo motu, they have powers to issue directions, they have power to issue penalties, and power to have interest. So there are huge and there are consequences of this. Now if somebody doesn't agree to the directions or an order given by the authority, then in that case he can appeal to the Real Estate Appellate Tribunal. Now this is established under section 43. Two important aspects which need to be seen as far as this is concerned. Under section 43(5), appeal of a promoter would be entertained only on depositing at least 30% of the penalty or higher percentage determined by the appellate tribunal. So please understand the importance of this provision. Minimum 30%, it can go to any further percent. Appeal has to be filed within a period of 60 days from the receipt of the order of adjudicating officer. There is one provision in section 44(5) which says that the appellate authority should make efforts that the appeal which is filed before them is disposed of within a period of 60 days from the date of filing of the appeal. Now this is an important provision mentioned in this particular act. If a person still has to go against the order of an appellate tribunal, then he can go under section 58, which specifically says appeal can be filed before High Court against the order of an appellate tribunal, and again the limitation period for this particular is 60 days from the receipt of the order. So if you see that adjudicating authority first, then it travels to tribunal, but when you come to tribunal there is a minimum deposit of 30% minimum, rest will depend upon what is the concept of the authority, and then if you don't agree to what authority is saying, then you have to file a proper appeal in High Court. Now this is the way in which the judicial things will flow as far as this act is concerned. Now we will proceed to see what are the offences and penalties which are being prescribed in this particular act. Till now we have seen the registration process, the rights, duties, obligations, the authority, the appellate authority. Now we will turn to the offences and penalties which are prescribed in Rera. They start from section 59. Now 59(1) is an offence when there is a non-registration of a promoter under section 3, and in such case the penalty is 10% of the estimated cost of real estate project. Now here something is more, so I have paused. As determined by the authority. Please understand, till the time all throughout the section up to 59 we are having a cost called estimated cost of real estate project, but here there is a qualification which is added saying that as determined by the authority. Now here some problems may creep in. This seems to be a grey area of working, but let's go ahead. As per section 59(2), if the order passed under 59(1) is not being complied, then in that case there is an imprisonment for a term which may extend up to 3 years, or with fine which may extend up to the 10% of the estimated cost of real estate project, or with both. Now here when we see 59(2) and when we read estimated cost of real estate project, it does not say as determined by authority. Then we have section 60. In case there is a controversy of section 4, then in that event a promoter has to pay 4% of the estimated cost as determined by the authority. Then we come to section 61. This says penalty for contravention of provisions of the act other than section 3, other than section 4, and any of the rules and procedures as prescribed in the act. Now it is again 5% of the estimated cost of real estate project as determined by the authority. Then we have section 62. Now this is an offence prescribed for real estate agents. So then there is a need that real estate agents should be cautious when they are dealing in the matters. It says that in non-registration and contravention, in that case liability is penalty of 10,000 for every day during which such default continues, which may cumulatively extend up to 5% of cost of plot, apartment or buildings, as the case may be, the real estate project for which the sale or purchase has been facilitated as determined by the authority. Then we have section 63. This is penalty for non-compliance of the order of the authority. It is again 5% of estimated cost of real estate project as determined by the authority. Now every time we are going through this section, it is important to note that here the concept of as determined by authority is playing a major role. Then we go to section 64, punishment for contravention of order of appellate tribunal. Now here promoter shall be imprisoned for a term which may extend up to 3 years, or with a fine for every day during which such default continues, which may cumulatively extend up to 10% of estimated cost of real estate project. Now here it is not written as determined by authority. Then we go to section 65, penalty for failure to comply with the order of the authority by a real estate agent. The penalty for every day during which such default continues, which may cumulatively extend up to 5% of the estimated cost of plot, apartment or building, as the case may be, of the real estate project for which the sale or purchase has been facilitated and as determined by authority. Now somewhere we get plain cost of real estate project, somewhere we get as determined by the authorities. Then we come to section 66. This is again an non-compliance of an order of authority by a real estate agent. In this case, the penalty is again 10% of the estimated cost of plot, apartment or building, as the case may be, of the real estate project for which the real estate agent has done sale or purchase has been facilitated and as determined by the authority. Then we have section 67, penalty for failure to comply with the order of authority, now for the first time by allottee. Then in such case, what is the penalty? 5% of the plot, apartment or building cost, as may be. Now here there is a grey area, as determined by authority. So whenever there is a question of laying down penalties either on a promoter or on an allottee, the discretion seems to be given, because nowhere we have this concept called a real estate project estimated cost as determined by authority. Then we have section 68, which has punishment for allottee again. Then section 70 is for compounding of offence. It clearly says that the offences can be compounded after or before the prosecution is commenced, and the same has to be done before the court. Now section 80. Section 80 is how does a court takes a cognizance and which is the court. So section 80 says it has to be by a complaint in writing made by the authority or by any officer of authority duly authorized by it for this purpose. Section 82 defines it is the magistrate court or the judicial magistrate first class who will determine and hear the particular offences. So till now we have travelled the sections of Rera. Now we will start with some significant rules of Rera as to how the Rera rules are being framed. Up till now, we have seen the various definitions, various sections as far as the Rera Act is concerned. Now we will go to the rules which are being framed for the purpose of implementation of Rera Act. Now what is the exact name of the rules? The rule is the Maharashtra Real Estate into bracket Regulation and Development bracket closed, registration of real estate projects, registration of real estate agents, rates of interest and disclosures on website bracket closed, rules 2017. So this is the entire thing of rules. Now what are the chapters in rule? Chapter 1 as usual is preliminary, chapter 2 is real estate project, chapter 3 is real estate agent, chapter 4 is rate of interest payable by promoter and allottee and timelines for refund. Chapter 5 details to be published on the website of authority. Chapter 6 miscellaneous. Hence in this particular rules, the total number of rules are 23. Forms in rule are from Form A to Form K, and there is an annexure in the rules, that is Annexure A, a model form of agreement for sale. We will see certain important definitions which are there in the rules. 2(1)(c) mentions apex body or a federation. Now this is more important because the conveyance fundamentally, if it is a layout plan and if it done in a phase wise manner, then in that case as per the Rera, the conveyance would go to that building only of the land beneath that building, and all common areas compulsorily would go either to the apex body or to the federation. Authenticated copy. This is particularly why I have taken this is self-attestation. So an authenticate copy means a self-attested copy of any document, which means for this purpose you need not go for any notary, you need not go for any SEO, you can do it yourself. 2(1)(j) covered parking spaces. Now the covered parking spaces are properly be defined and mentioned in these rules. Then we have 2(1)(p), which is phase of a real estate project. Now this is a very interesting definition and we need to understand it. May consist of a building or a wing of a building in case building with multiple wings, or defined number of floors in a multi-storied building or wing. So by third we can see that if a building is say of 40 floors, these entire 40 floors can be defined in phase wise manner and they will be considered as a phase of real estate project. Then we have redevelopment scheme. As to what do you mean by redevelopment scheme? A scheme inter alia providing for allotment of apartments in respect of rehabilitation or redevelopment of a slum area or a dilapidated building, whether cessed or not, or cluster of buildings as may be approved by the relevant competent authority under the provisions of any state or central or orders of state or central government. Now this certain definitions were important, and one of that is the phase in which a project can be done. So once we know this, now we will travel to our next segment and we will discuss some important rules which are framed in this. We will now see some important rules which are there. Rule 3. Information to be furnished by the promoter for the registration of real estate project. In that, there is rule 2, rule 3, sub rule 2, H. The nature of the organization of allottees to be constituted and to which the title of such land parcel is to be conveyed, and the specific local laws to govern such organization of allottees on completion of real estate project. Now the moment we read this particular rule, it becomes absolutely clear that as in case of MOFA, there was a liberty to mention the form of organization and to decide it at the end of the project. Now that liberty no more survives, which means at the time of agreement of sale, it is binding on a promoter that he has to mention which kind of an organization, which type of an organization he intends to form once the project is completed. Then we have the fees to be paid by the promoter, that is 3/5I. The fees are to be calculated at rupees 10 square meters, subject to minimum of 50,000 and maximum 10 lakhs. The fees of the registration should be paid through NEFT or RTGS system or any other digital transaction mode. So this makes it very clear that whatever are the payments, they should be done with the help of net banking. Then we have 3.8. The promoter shall disclose. Now in this particular section or a rule, the promoter has to give 3 types of cost. Cost number 1, land cost. Cost number 2, cost of construction. And cost number 3, estimated cost of real estate project. So 3 costs will be there in one single real estate project. Rule 5. Withdrawal of amounts deposited in separate account. This rule lays down the method and the manner in which the amount can be withdrawn from separate account which has been formed by depositing 70% of the amount received from allottee. In this particular rule, there are 3 certificates which are needed. At first, it is the certificate of an architect as regards the completion, percentage completion of the work. Second, it is the site engineer who gives the percentage of cost of construction incurred. Based on this, and chartered accountant derives a formula which is mentioned in this rule, and from that formula it is decided how much percent of the 70% amount can be withdrawn. Rule 7. Extension of registration of real estate project. This rule has force majeure mentioned in it. Rule 9. Formation of legal entity and transfer of title. So formation, and then it stipulates the time within which the conveyance has to be given. Rule 10. Agreement for sale. The promoter is free to deviate from the model format given, but provided the promoter abides and adheres by the law and the provisions specifically mentioned of section 13(2) of the Act. So a promoter may differ from the annexure A model format given of agreement, but that variation should be within the ambit of the provisions of section 13(2). Now this is a different aspect. Rule 11. Application for registration by a real estate agent. He, a real estate agent, has to apply as per a form G which is annexed to the rules. Rule 11.3. The amount at the time of registration to be given by a real estate agent. If a real estate agent is an individual, the fees is 10,000. Whereas if the real estate agent is a non-individual, then the fees is rupees 1 lakh. Again, the same fees have to be paid through NEFT or RTGS or any other digital transaction mode. Then we have Rule 11.5. The real estate agent, upon being engaged by the promoter for a real estate project, shall maintain and preserve books of accounts, records and documents separately for each real estate project, which clearly means that if one real estate agent is registered with 2 promoters, he has to keep 2 separate accounts of that particular real estate projects. Rule 12. Grant of registration to the real estate agent or rejection of registration. The registration granted under this rule shall be valid for a period of 5 years. Rule 13. Renewal of registration of real estate agent. A real estate agent to whom registration has been granted may make an application for renewal of his registration at least 60 days prior to the expiry of registration. The application shall be in form J and shall be accompanied with the same fees as are applicable in a case of new registration under these rules. Rule 13.4. The renewal granted of registration to a real estate agent will be valid for a period of 5 years after renewal. Rule 14. Obligations of registered estate agents. Rule 15. Revocation of registration of real estate agent. Rule 17. Other functions of a real estate agent. So when we see this, we can see that various obligations are being casted upon the real estate agent and it is mandatory for him to abide by them. Then we have Rule 18, a rate of interest payable by the promoter and the allottee. Now what would be that rate of interest? That rate of interest would be State Bank of India highest marginal cost of lending plus 2%. Rule 20. Details to be published on the website regarding real estate project. Rule 21. Details to be published on the website regarding the real estate project. We hope that the effort made by the team Hammurabi to throw some light on the new act called Rera and its rules would really help and benefit people, and the people will take this for their benefit. Hoping this, we take leave of you. Thank you. Namaste.